107-410, State of Kansas v. Alexander.
May it please the court, Christina Curls of the Appellate Defender Office representing Mr. Alexander. I will request 3 minutes for rebuttal.
3 minutes is granted.
I am going to focus my argument on the first issue of the brief and submit the other one on the brief. The first issue deals with the district court's denial of Mr. Alexander's motion for psychiatric care and treatment in a state security hospital, specifically Larned State Hospital, in lieu of imprisonment in this case. The Court of Appeals decision was based upon the fact that prior Supreme Court precedent found that this issue was completely unreviewable. In State v. Mastis, this court reversed, overruled prior precedent and found that this type of an issue is reviewed for abuse of discretion. So if there are no questions on the reviewability, I'm going to go straight to the merits of this issue.
We decide the merits? The Court of Appeals opinion that's before us for review was a dismissal based on lack of jurisdiction. So we find that's erroneous. Do we go ahead and decide the merits, or do we remand to the Court of Appeals?
I think the record is sufficient for this court to decide the merits. However, I think remanding to the Court of Appeals for reconsideration would also be appropriate. I can present arguments on the merits if this court would like to hear them. I would also agree that remanding to the Court of Appeals for reconsideration in light of Mastis would also be an appropriate avenue or appropriate disposition for this case. With regards to the merits, the statute in question in this case is 223430, and there are 3 requirements in order for a defendant to be sentenced or to be sent to a state security hospital in lieu of treatment. The defendant is in need of psychiatric care and treatment. Treatment would materially aid in the defendant's rehabilitation, and the defendant and society are not likely to be endangered by permitting the defendant to receive this treatment in lieu of prison.
Your problem's the second one, isn't it?
Yeah.
That he can be assisted by treatment? Because his diagnosis indicates he's not really amenable to any effective treatment.
I wouldn't necessarily say, I wouldn't necessarily agree with that. The doctor in this case did testify. The question was asked, would treatment materially aid in the defendant's rehabilitation, and the answer was certainly. It then went on to explain later on that because this defendant has a personality disorder, that's going to be something that he's always going to have to deal with and adjust to. Our argument would be that psychiatric care and treatment would help him both medicinally and give him the therapy to learn how to adjust to that, how to make his behavior, how to deal with that personality disorder.
No cure, but treatment would still be helpful.
Exactly.
Okay, thank you.
And didn't Larnard say that he could obtain that help within the regular system?
The doctor did state that if he was placed in the Larnard Correctional Mental Health Facility, the medicinal treatments were available. He did explain that due to budget cuts, a lot of the counseling programs were cut down on. But he also explained that there was no guarantee that Mr. Alexander would be placed in the Larnard Correctional Mental Health Facility, that he could be placed, in general population in any one of the other correctional facilities. So there was no guarantee that Mr. Alexander, with his motion not being granted, would actually receive the treatment that he was in need of, that the doctor testified that he was in need of, and the district court acknowledged that he was in need of.
Didn't the district court judges kind of look at all the ramifications, kind of summarizing by saying he wished he maybe could place him in the more secure facility, but it's almost an exercise in futility because after 5 or 6 months they're going to stabilize him from whatever he's suffering from. He'll come back before the court, be placed in incarceration, and kind of go through that procedure. And in fact, he already received some of that treatment and was stabilized, was in that was in that posture at the time of sentencing. So at the time that determination was made, I just don't see where that's an abuse of discretion to take everything that he considered at the time. I understand the struggle here. I understand your position, and you see the delusions that your client is under from some of the communications with the court, but all that was taken into account, wasn't it?
It was taken into account, and I guess our argument would be is that the following statute, 3431, deals with how to release a defendant back into incarceration, and to make the determination of whether or not the defendant should receive treatment in lieu of incarceration to begin with. The length of the treatment needed isn't a factor to consider. It's the three factors that are in the statute, and those three factors were met. The fact that he may later be stabilized and be moved back to the DOC, that's an issue for a different day at a later hearing. And we would argue that the district court shouldn't have taken that into consideration when determining whether or not this defendant should have received treatment at Larned State Hospital in lieu of imprisonment in its initial decision.
I'm not sure I track what you just said, because I thought in Maestas that we said once you meet the three factors, that doesn't guarantee you a spot. All that means is that the district court has it teed up
Yes.
to exercise its discretion. And so, I mean, are you saying that that it's an abuse of discretion once you've met the three factors?
And I wouldn't say that it's an abuse of discretion once you've met the three factors. I would, because in Maestas, which was also one of my cases, this court didn't find an abuse of discretion because in that case, the psychiatrist or the psychologist's report and his testimony didn't actually meet those three factors. In this case, that absolutely was the case, and the district court found that was the case.
But the psychiatrist still recommended that he receive an ordinary disposition. Did he not?
The psychiatrist recommended that he should receive an ordinary disposition, but that seemed to be based upon, in his report, seemed to be based upon the fact that the defendant was able to participate in the legal system, that he understood what was going on around him, and secondly, based upon his testimony, his belief that the defendant would be placed in the Larned Correctional Mental Health Facility within the DOC. But then he went on to acknowledge that that was no guarantee that the defendant may or may not actually receive that treatment or receive that placement, and if he didn't, he wouldn't be receiving the treatment that he needed. Our argument is that the factors in this case were met, or the requirements in this case under the statute were met, and if this court does decide on the merits, we would argue that it was an abuse of discretion for the district court to deny the motion for treatment in lieu of imprisonment.
Can you refine your argument? I'll grant you, for purpose of argument, that the three statutory factors were met. What's your best case for why the district court abused its discretion, even given that the three factors may have been met? How specifically did the district court abuse its discretion?
Specifically, we would argue that the district court abused its discretion, A, by considering factors outside of the requirements, by considering that this could be a short-term, because this might be a short-term incarceration, he couldn't, and his words were, I cannot place him in treatment. He said that specifically in the sentencing,
Doesn't the Maestas case assume, essentially, or presume that the district court could consider additional factors? In other words, it says, once the factors are met, now the district court has the authority to provide this treatment, but it's not a guarantee. How is the district court to make that decision?
I would agree that it's not a guarantee. I think that they should look at the factors, and I guess my argument would be is how, within those factors, how the defendant fits. I mean, in this case, the district court looked to the potential for short term, which we would argue was premature. The potential that it could be short term treatment. We would argue that for the district court, it would be, I guess, the degree of the need for care. I mean, A
So
lot
you're-
of, like, I'm sorry, go ahead.
Oh, that's all right.
I'm trying to,
As I understand your argument, you're saying that the district court is limited in its exercise of discretion to the 3 statutory factors. Is that a fair restatement of your argument?
I would say so,
Okay.
yes. And,
And
go
to
ahead.
follow up on that, as you're aware, when we say an abuse of discretion, we, in the last couple of years, have refined that standard and talked about 3 different ways when that can be done.
Yes.
Okay, which of those 3, if any, are you relying on?
Trying to think here for a second. I would argue that first of all, it could be considered arbitrary in a sense that once the 3 factors are met and one defendant gets the treatment in lieu of prison and another defendant doesn't, when those same 3 factors are met, that can be arbitrary decisions on the part of the district court. Additionally, given this particular defendant and his history, he was in mental hospitals for 8 years, from 88 to 96. At the beginning of this case, he wrote the judge indicating that the sheriff was after him and trying to incriminate him for his crimes, and if he was incarcerated, the sheriff would have him executed. During one of the evaluations, he indicated that one of his prior clients owed him $600 billion for work that he had done for him. The degree of, I don't really know how to phrase this politically correctly, but the degree of issues that this particular defendant had, we would argue that it was unreasonable and that no reasonable judge, particularly one who acknowledges that this defendant needs treatment and hopes that he can receive that treatment while understanding that's not guaranteed, would act in the way that this judge did.
So no reasonable person would agree with this judge.
Yes, given the acknowledgments that this judge made and his acknowledgement that this defendant needed treatment, we would argue that no reasonable judge would deny this request in hopes that he might receive this treatment when sent to the DOC.
All right, thank you. Do you have any further presentation?
I do not. I would just ask this court to reverse the decision of the district court.
Do we have any more questions? Thank you, counsel.
May it please the court, Chris Elsliger, appearing on behalf of the state. I came into this case fairly late. The attorney that handled it below has long since left our office, so you can imagine what a pleasant surprise it was to dig into Westlaw and find that the whole reasoning on which the Court of Appeals decision was based has been overruled earlier this year. So, assuming that the court now has, I mean, since he didn't remand it, I'm assuming that we're going to talk about abuse of discretion, and based on opposing counsel's presentation, I guess I was right. And I would say that simply, I read through the record of the sentencing, and based on the testimony of the psychologist, I don't know how anybody could conclude that the district judge here was unreasonable or arbitrary or in any way abused her discretion. I mean, the doctor, the psychologist himself said, this guy has problems, but he can receive the treatment he needs. He can get in the Department of Corrections, and I see you thumbing through the transcript there. I believe that was on page 12 of the sentencing, and again page 14, and again on page 19. He said that the defendant he recommended that he receive routine legal disposition based on his charges without regard to the clinical issues. There was no reason to go outside the regular legal system, and it is outside the record here, but I would point out I just checked the DOC website, and this defendant is in the Larned Correctional Mental Health Facility, so he's getting the treatment. But back to the sentencing, I mean, that was the evidence in front of the judge that yes, he had problems, but there was no reason that those problems dictated that he needed to go outside the regular legal system to go to the Larned State Hospital. And, the judge acknowledged that. And the judge also acknowledged her own experience in the past that in addition with what the doctor said is that this when you commit them in lieu of incarceration, they just go until they're stabilized and then they come back. And the doctor said basically that Larned State Security Hospital treats them when they're psychotic, and once they're stabilized, they send them back to DOC. And there wasn't any evidence that this guy was psychotic. He was stable, and so if the judge sent him to or committed him in lieu of incarceration, he'd be back very quickly because he was pretty much stable. So when you add all that together, I don't think there's any argument that any reasonable argument that the judge abused her discretion.
So I want to clarify the district judge's hesitation that Mr. Alexander would be back in court in 5 or 6 months. Wasn't that he would go to Larned and become stabilized, but that he was already stabilized, so it would be an exercise in futility rather than just a short-term fix. You understand my difference in my question? I see it's different that, we're going to send him and get him fixed, but it's not going to take very long, and so it's just going to be a waste of time, versus saying there's nothing to fix, so it would be a waste of time.
Yeah, the judge kind of seemed to say both.
That's what I sort of understood.
But when you look at, I remember what Dr. Downs said is that essentially he is stabilized right now. So there's no, I mean, I think if you fall back on the evidence that was in front of the judge, if you take aside the judge's prior experience and her comments about, well, it's going to, it'll be a short-term thing before he's back. If you take all of that out and just look at the evidence that the doctor presented, I mean, the doctor said, look, there's no reason that this guy needs to go to commitment in lieu of incarceration. He's stable. The treatment that he needs, he can get in the Department of Corrections. And I think and that's the only evidence that there was. So, I mean, there was arguments of counsel suggesting that, hey, yeah, the doctor, says he needs treatment. He should go to treatment in lieu of incarceration. But there was no other testimony that said he couldn't get what he needed in DOC. I mean, the expert said, yeah, he needs some care, but he's getting it, and he can continue to get that in DOC, and there's no reason to go outside of the regular legal process. I think if you just look at that alone, that is sufficient to support the judge's conclusion, and I don't think that you could say it was an abuse of discretion.
Can you explain to me again why you think we ought to reach the merits?
Well, like I said at the beginning, when I got the case and I started reviewing it, I wasn't quite sure. I'm really not quite sure. I mean, you could have remanded it back to the Court of Appeals for further consideration in light of Mastis, and I assume that since the court didn't, you've presumed that the record is sufficient for you to make that determination. And I think the record is not significant. I think you can make that determination just as well as the Court of Appeals. But as opposing counsel said, it's perfectly within your rights to send it back to the Court of Appeals. So, I mean, that's about the best I can give you there.
Fair enough. Yeah.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Unless the court has further questions, I would waive my rebuttal.
I see no questions. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.